Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. For the past 15 days or so, we have discussed a couple of cases regarding the cruelty to the woman, or particularly dowry harassment cases, or you can call it, as everybody knows it, 498A cases. Once again, another judge of the Bombay High Court, she voiced her dissent, or she voiced her concern over the false implication of the poor relatives of the husband residing elsewhere or at a long distance. So, single judge, Bombay High Court, Aurangabad bench, Justice Vidisha Kankanwadi, maybe a lady, Vidisha Kankanwadi. So, while deciding the case of Jyoti Ganesh Patil, normally we call her as Jyoti Patil, versus State of Maharashtra, in criminal appeal number 440 by 2022, decided on 8th July 2022, voiced the High Court voiced its concern over the trend of roping in the relatives of the husband in cases of 498A as well as the Domestic Violence Act cases. We have discussed two cases previously. So that means the misuse is still continuing. Right? So, please remember, basically you all know what is Section 498A. Section 498A IPC relates to the punishment for subjecting a married woman to cruelty. It's an offence punishable for 3 years or so. So no doubt 41-year notice has to be given to each and everybody. Right. Here, if you go to the facts of the case sometimes, so it's a very tricky case. Very simple to say that the husband, the poor relatives are roped in, but the proof is very difficult. So the complainant, because she is a lady, her name is not given, I believe. The complainant alleged that her husband and in-laws, as well as the appellant, that is Jyoti Patil, they had been torturing her and subjecting her to domestic violence. So, Domestic Violence Act 2005 has also come into existence. Right. Now, normally the allegations against husband are quite common. Even against in-laws are also common. But here the important or pertinent point to note is the complainant, the lady or the victim herself, disclosed that the in-laws were residing in Pune. These people are residing in Bombay, they were residing in Pune. And this Jyoti Patil, she was residing in Busawal. And she was working as a veterinarian, that means a veterinary doctor, maybe a veterinary doctor or a compounder, I don't know. She is working as a veterinarian in Busawal. Busawal is, you may be knowing, on the way to Shirdi. Previously, when we used to go by train in State Express, forgotten the name. It goes to Ahmedabad from Chennai. So in that express, we used to cross Busawal. Then only in Mahanagar Express we have traveled. Anyway, this Busawal is nearer to Shirdi. So, but far from Bombay. No doubt they are in only one state. But Pune is a 3 hours journey from Bombay, and Busawal maybe around 5 to 6 hours, like that. But here, what the court observed is, why it has quashed the proceedings is, please remember, our appeal was allowed is, when you allege something happened in the hands of the in-laws. When you say that something happened or harassment by so-called Jyoti Patil, then you have to prove it. With what? With dates, with time. So please remember, when you say that they are residing elsewhere, at what point of time the appellant was, harassed her, Jyoti Patil harassed her. Then simply saying that that woman telephoned, basing on her telephone conversation, my husband bet me, and my father-in-law and mother-in-law, they used to say that normally, you know, if you die, then we'll get married to some. These are not the elements of the harassment. Of course, no doubt, they are a part of the harassment, but you have to prove the same. This is important. The typical point what I want to tell is, suppose if you want to allege that the so-called Jyoti Patil did something, it has to be, actually the evidence has to come in the shape of time, place or any corroboration. Unless you say, otherwise it becomes an omnibus or general allegation which need not be proved, and therefore the court is of opinion, but this is not a correct allegation or false allegation. So please remember, the court has to be satisfied as to what point of time the appellant harassed the victim. So the basic pleading, the basic evidence is lacking. So ultimately, the court is not satisfied with the allegations by the complaint in the particular case. Ultimately, the appeal was allowed, and for roping in the relatives of the accused person or Jyoti Patil in 498 case is held not to be to be treated by the lower court. Anyway, the appeal is allowed and the conviction is set aside by quashing the entire proceedings. So this is a good case law. Please read it and enrich your legal knowledge. Thank you very much.